Party couldn't have been silent on that because Labour Party is the only party that won 25% and above in Abuja. So there's no way we could have been silent on that. The only party that won 25% and above. Others came distant second and distant third. How can an institution, public institution like INEC, certified blank documents and said that it's certified polling unit results, certified photographs and said it's certified polling unit results?
The Presidential Petition Tribunal sitting in appeal court closed case today. Judgment is here. Who becomes the President of the Federal Republic of Nigeria, the most populous black nation on earth, the giant of Africa that is asleep? Who is going to wake the giant of Africa from her slumber? Is it Tinubu, who is sleeping in Benin Republic as we speak, or Atiku Abubakar, who lives in Dubai and comes to Nigeria to contest for the presidential election every 4 years, or the trader, His Excellency Mr. Peter Obi, who lives in Anambra, in Onitsha, in Anambra State, Nigeria here, who trade, who move around Nigeria, and then have this feeling of what Nigeria think about Nigeria. That is what some people say, no, we talk about. So now, the petition in the courts, they have filed, the petitioner have filed their final response, of which I brought to you. Now, the respondent have done same. There have been no back and front here and there. So this is the adoption of the cases before the Presidential Petition Tribunal in Appeal Court, Abuja. Respondent filed a written address dated and filed on the 14th day of July 2023. The fourth respondent replied on point of law, which is dated the 27th day, by filed on the 28th day of July 2023. Respectfully, I adapt and rely on those two processes. I urge the court to dismiss this petition. I will adapt the oral submission of my A.B. Mohammed and our led chief, Wolu San. I have refilled myself, but I have to be mindful to say that this petition is ambitious. The second petitioner has abused process. They suffered defeat in Abuja and run to Lagos. They had a short victory. As the court appeal shows, the result were destroyed. Unless there is an appeal to overturn the decision of that court, this procedure here is a gross abuse of process. The investigation is in an election is to see whether voting took place, the result declared, and collation was done. I will give it to them where they have done well, and that is that they did not dispute that voting. Counting, collecting, and result are the important things. The one at the unit level is the most important. If anyone wants to attack the result, there has to be the polling unit. By polling unit, allegation and proof. If they are contending that there were continuation with the transmission, it has to be polling unit by polling unit proof, which was really lacking. This is the submission by APC. I wouldn't want to go bore you with a lot, but it's just a little, summary of what APC said. They said on disqualification means anybody is qualified except he suffered under the provision of section 137D of the Constitution. It is not a criminal forfeiture. There was no charge, no trial, no conviction. So Exhibit BA is devoid of the requirement. The question of the status of FCT does not enjoy any special status as far as elections are concerned, especially presidential election. The second respondent scored more than 25% in and about 29 states. That suffer or to do otherwise will amount to constitutional arbitrary. On the issue of IREF, there is no point that has not been decided. The case has been decided already. So that is it from APC. To call weakness, they never called weakness. but to call for disqualification, asking for glitches and technical whatsoever, That is what they are trying to look at now. Let them declare or dismiss this case. Now, here is the response from Peter Obi Legal Counsel, the petitioner. Dr. Oliver, in reaction of the address by the first respondent, the petitioner filed their final address on the 23rd of July 2023. That was what happened. Then we want to submit that the respondent have labored in vain to dismiss the impotency of IRF, and in the case of Oyotola versus INEC, which firmly stated that IRF is part of the electoral process. I will refer to all the witness deposition of RW1 because I will like to drag them out of their comfort zone. He said, I know that the authentic and statutory prescribed is the IRF portal. They are trying to downplay that an election which 18,088 blood results were uploaded to the IRF is a faulty election. There is something remarkable about this matter. INEC issued certified true copy of polling unit results to the petitioner. Out of that number, 8,123 were blood certified by INEC. Some were black copies of A4 papers. Also among them you have pictures certified by INEC, pictures of people, pictures of houses, and all of that. Court now responded, we are not writing because it is in your written address. Everywhere momo in the court. Dr. Oliver now continued. He said, how can they say they conducted an election properly? It is my respectful submission that the certified true copy of any document in a result must be an exact replicant of the original. They failed to produce the original of the copies they certified because it couldn't be any other than black sheet. Let me go to the issue of fine or forfeiture, which the second respondent talked about. It is not in doubt that the second respondent forfeited $460,000 as proceeds from narcotic and money laundering. They do not want to hear that. We clearly relied on section 1371D, but they are pushing it to another section. Section E. You cannot make our case for us. The provision says any court or tribunal. It is very clear, my lord. There is this attempt to claim that the first petitioner is not accommodated under section 134. The submission that in the case of rerun, there is the argument that the first petitioner will not be accommodated. The only candidate who comes squarely within the provision of section 1343B is the first petitioner. Even if the created wrong interpretation, it cannot work. The case of Awolowo versus Shagari was cited. Of course, the provision now of the Constitution was not available to interpret that case. Let me quickly refer to what my brother for second and third respondents said, that the petition was abandoned. I couldn't believe this coming from my brother whom I respected. My brother did not argue you to interpret, and as being disjointed, I didn't hear that. I submit with the greatest respect that the petitioner have proved their petition, particularly with the issue of non-compliances. They had no defense at one point that they said it was the printing toner that caused this issue. At some point they said glitches would have caused it, but the alleged glitches lasted only 4 hours. But up to 29th of May, they were still giving us blood result of the election. Finally, the petitioner have proven that there was no glitches whatsoever, as alleged by the respondent. That was how Dr. Olivia, finished